Any associate with an unlicensed assistant is responsible for ensuring the unlicensed person never acts as a salesperson. It is actually a crime for an unlicensed person to engage in activity in which a real estate license is required. The licensee who employs an unlicensed person might be criminally charged for the crime as well. TRELA 1101.351 and 1101.758. I didn't make that rule up. That's actually verbiage that's straight from Texas Real Estate Commission. If you, who has, I'm not going to go into who's, let me just ask you, how many of you have unlicensed assistants? Raise your hand. Okay. They are very minimal things that those assistants can do in this business, and it's getting harder and harder for them to conduct the services they would need to do to serve you well. I strongly encourage every single assistant that we have in this company be licensed. I'm sorry, it's just too much liability. You know what, and folks, the consumer and the public and the other vendors and the other licensees are expecting it. So if you've got a licensed assistant, I respect that. They can really do most of any of the duties and skills you have them do. If they're not licensed, folks, there's so few minimal things that they can do. Yes, sir.
Would y'all be okay with the team leader paying for the assistant to go through the...
Oh, yeah. Matter of fact, what I did for mine over the years, the question is, did I... Yeah.
Not this team leader.
Be
careful here.
As a team leader of a group or team over the years, that's been 15 years ago, I paid for two of my my unlicensed assistants that they were unlicensed at the time. I put them through school. They were like children to me, and I had them for years. Those folks went now to other business models and have done very well, but they were unlicensed, and I felt it was to their benefit, long term, and to mine, to see that they get licensed. And matter of fact, Dustin Curley was one of my, he married actually one of my first assistants 15 years ago, which ran my team. She ran my team for years. Dustin never worked for me specifically, but he married my assistant. And then he got licensed. So I do recommend you get licensed. Okay.
Hold on. Linda? Repeat the question.
Hold on.
Guys.
So I'm trying to qualify. Since I have someone that will go just to unlock the door on a company tour if I can't possibly make the company tour. They don't say a word to them. They just say I'm Linda Stevens' assistant.
A company tour in which you are the listing agent?
Yes, sir. And
I don't have a problem with that.
Okay.
I mean, you do take liability for the company if there's something does happen. I'll share with you one thing that just happened those 2 weeks ago that scared the Jeezies out of me. But being that they're not licensed does put a little more risk. But with that being that they're just going to open the door, they're not going to communicate with the consumer or client. They're merely there to provide that service. As a broker, I'll take that risk. Real quickly, agent 3 weeks ago, 2 weeks ago?
2 weeks.
2 weeks ago, right? Female agent, newly licensed, going to be an up-and-coming agent, went out to open a door at a property that we had the listing on. The seller was upstairs in the shower. Evidently CSS called, but they were running 15 minutes late. I think 15, 20 minutes late. She did not call in to tell them they're running late, but that's typical of agents. Do we not run late sometimes? She turned the alarm off downstairs. Her husband and the buyer were at the door and were coming in. While she was turning the alarm off, the seller upstairs thought it was a burglary, came outside with a 9mm gun, shot the husband. The husband is a Bexar County Sheriff Department deputy. Luckily he wasn't armed because he would have shot her back and would have hit her. The lady she was so startled because evidently she had been burglarized before. She thought the husband was a burglar because he came in the house with the wife, which was a real estate agent. He was wearing shorts. If you looked at him, he's kind of a big, brawly guy, no hair, nice guy. His name's Chris, and he had a tattoo on his thigh. So I guess she thought he was a thug or something of the nature and didn't think he was a real estate agent. She shot him in the shoulder. He lived. And I went to the hospital that night, and believe me, I went home and I prayed. So I tell you that story because of being licensed. Is that going to protect them any much more? I don't know. But now, what would have happened if she's not licensed? She doesn't know that the skill sets involved in ringing the door, making sure, hi, I'm a realtor. Make sure you're doing those steps because we do get a little more training than unlicensed people. Would you agree with that?
Yeah.
So look, get licensed. This is a profession. Treat it as a profession. Number 10. It had a good ending though. Evidently the buyer didn't buy
She
the
will
house.
never be late again.
And her husband is not going to any more company showings. He said he's the only time he's ever been shot and he was in real estate. How's that? He does want to get his license. That's pretty crazy. He's been a liability. I guess I'm going to take another policy out, right, Henry? Yeah. All right, number 10. All groups and team leaders must take responsibility course by the end of 2013. Husband and wives are not required to do it, but they're encouraged to do it. So if you're a team, a lead agent on a team or a group, other than your spouse, so if you're if you're a spouse that just has you're just bossing your spouse around in the business, that doesn't count. We know who you are. But if you are a lead agent, raise your hand. If you're a lead agent, raise your hand. We don't have too many. Okay, folks, you got to take the broker responsibility course. I know some of you may have already taken it. By the time your license comes up in 2013. Yes, sir.
If you have a licensed assistant, does that make you a group?
Nah, do you have to take the responsibility course if there's an assistant that's licensed?
They're not active. They're not selling.
They're not selling. I would still take it. Yeah.
It's a great class.
Because here's what will happen. If you get a complaint filed against you, and your agent, your assistant, was administering, communicating, something involved in that transaction which is docketed by Texas Real Estate Commission in the investigation, then you are responsible, according to TREC, as the lead agent for that. You're responsible, a lead agent for that member. Regardless, TREC doesn't care if they're administrative or selling. We only care about that. They don't distinguish that any different. So they probably would still fine you. Because you take the responsibility course. It's just, again, it's like a DBA. It's just better safe than sorry. Okay, number 11. Come on. All group and team lead agents must have signed group and team hold harmless on file with the office for each member of an agent and provide a copy of their members' independent contract agreement to agent services outlining the relationship terms, commission, and exit clause. Here's the reason why we do this. I don't know if we're enforcing that as much as we are in San Antonio, but here's the problem I have in San Antonio. I have a lead agent, comes to me, has a great team member. They've been in business for 6 months. Of course, it's real estate utopia. They sold a couple of homes. It's the greatest thing since sliced bread. Buyer's agent and lead agent on one deal go sideways. Buyer's agent says before it closes, I want the entire commission, or tries to get the commission given to him. And yet the lead agent says, no, that's the team commission. Well, now the buyer's agent comes to me, and guess what they want to do? They want me to write the check to them. Folks, I'm not going to get in place of your team, and I'm not going to take the drama and the liability that you create on your own. Lead agents, if you've got a member that's going to join your team, I am not going to write, and the brokerage is not going to be responsible for writing your group team member the check. It always goes to the lead agent. I'm never going to do it. Because I don't want to get into he said, she said, who's right, who's wrong. In my book, the lead agent is the team. They will receive the check, but I do need an independent contract agreement that you do have between you and your buyer's agent or your team member, outlining how that commission will be conducted. It's at least put in our file, but I want you to hold harmless for me between you and your team member if there's any commission disputes. I'm not getting in the way of commission disputes any longer. It's not my cup of tea, because I never make anyone happy. You know what I'm saying? So if you're a member on a team, I'm just going to tell you right now, don't come to me if there's a commission dispute. Go to the lead agent. You have to work it out with them. And by the way, Texas Real Estate Commission is not your answer. They're not going to see that case. They're not going to get into commission disputes, right? Correct. They don't see them. All right, number 13? 12. Under no conditions will a current licensed KW associate be permitted to join a group or team. Obviously, this is the way it works. We ever heard of saying we don't eat our young? Right? I'm not going to let any agent here cannibalize the agents that are already here. If you want to build your team and you fit the criteria to do so, do it, but don't do it through our own agents. If you're here, you pay your own cap. There's no cap sharing. End of story. We don't tolerate it. We don't tolerate it. You can't have agents join your team that are currently in our company. Zero toleration for it. And it's not even a conversation you should be having. And I've seen other offices literally be cannibalized, and it has hurt the brokerage long term, and it affects your profit share. And it's just not a fair, it's not a win-win. If you want someone on your team and you fit the criteria to build your team, then find them outside the company, not within our company. And that goes within Keller Williams in general. Why would we go to our own Keller Williams offices to cannibalize them? Right? You know, look, it's hard enough to get great agents like yourself here. It's even harder if we don't have your support once you're here. Right? Number 13. Last one. Any licensee who structures the business as a corporation or a limited liability or general partnership must have a broker's license to receive commissions. I know many of you are probably told by your CPAs or your accountants, go form your own corporation. How many have been told that? And I want you to. Great. But the only thing we can't do is write your corporation the check or your LLC the check unless A, you're a broker, or B, actually that's the only thing. If you're a broker that you have, if you're an officer and broker of your corporation, we can write you the check. Otherwise, we'll give the check in your name, you deposit it in your corporation and tell your accountant to figure it out. Yes?
Does that mean the individual has to have a broker's license, or the corporate entity has to have a broker's license?
For the corporation to receive a commission, if you want me to say to the broker to write the corporation check because you're doing it for tax purposes, unless you're a broker, I can't write you the check. And I'm not going to be a corporate officer on your corporation.
The individual has to have the broker's license.
Yes.
So does the entity does.
So the entity has that, yes.
Okay.
See, I can pay, Trek allows me to pay every one of you a commission, but Trek won't allow me to pay an unlicensed corporation. If the corporation does not have an officer, which is the actual broker of record and registered with the Texas Real Estate Commission, I can't write you a check. Sorry, have a nice day. Doesn't mean, now here's the thing, doesn't mean you can't still receive that check and you deposit in your account. What you do with your money is your money. Just talk to your CPA about it. That's the best way of doing it. All right, I'm done.
Okay. All right.
Meeting adjourned.
You got to ask the question. Did anybody not learn something there? Okay. And we even brought that one up last week at the team meeting. But seriously, right there in just 1 hour's time, you had to pick something up there that will help you change the way you're practicing and keep you safer. The big deal is not necessarily the TREC violation, it's what you go through with that TREC violation. It is a complete invasion of your entire life. It's awful. It is awful. And I'm the one who sees this when somebody goes through this. And we've had a handful of you in here that have gone through something. Right now, this should have helped you. Now, if you need clarification, we can go through that later on. But just know these are the basics, and these are not mandated by just the brokerage. This is TREC. We've kind of been skirting through this. The signs, a lot of you aren't doing 50% of the Keller Williams sign there, but you need to. And it's not tomorrow, but you got to put those pieces in place. That's all. I don't want you to panic.
There's a
right
new
now.
TREC director, and he is not messing around. He's ex-military, and he means business. And I'm telling you, it's gotten a lot. They're not running TREC the way they used to run it, and we're seeing it. The investigations are getting more fierce, and they're coming more collectively. So, folks, there's the season's here. Just try to ride the rules, and you'll be fine.
And a lot of these rules are here for your own protection. They're here to keep you out of trouble. They're a pain sometimes, but don't view it as an adversary situation. A lot of those rules are there to make your job easier and to keep you from getting into trouble.
Very well said. Okay. Can you hear me?
I think you need to turn her up a little bit.
The volume?
Yeah,
They got it.
Oh, okay. All right. Okay, now what we're going to do is this is the next housekeeping issues that we're going to take care of. And then what I'll do is I'll give you a 10-minute break, and then we're going to start the panel when you come back, so it'll be all the panel when you come back after your break. Okay, compliance requirements. Well, as of June 1st, it's going to be a little bit more difficult for you to get through compliance with the way that you're doing it now. There will be no more listings and contracts together in the same loop. and provided a day or two before the closing. And the reason I say that is part of this broker's responsibility is to receive the listing when it is effective and the contract when it is executed. No exceptions, period. For you to do otherwise, unfortunately hurts you, because when we are forced to have a report by this broker on the issue of a complaint, he's not going to lie. He has it documented. He knows its date and time stamp when you first provided him the ability to review. So there will be no more exceptions to that. The other thing is you're going to need to get into your classes with Nicole Joyce, because if you upload any blank forms, the loop will be sent back to you. You will archive all of those documents that are not necessary in the transaction and then resubmit. We will no longer look at 63 pages of blank documents. It has taken about 8 to 9 times for us to get through it. When you upload the contract 7 times, well, I looked at it 7 times to just make sure that something didn't change. That's no longer acceptable. We will not do that. The other thing is there's going to be an additional requirement on the listing side. I better be able to see that CMA, the comparative market analysis signed by your sellers, or the broker price opinion signed by your sellers. Otherwise, your listing will not be approved.
Well, it's a TREC violation, period, end of
Yeah.
story.
And it is. It's what TREC's rules are, and this broker has to abide by them. Unfortunately, it has hurt the agents that did not provide the listing and the contracts to the broker when there was a TREC complaint. And that's the problem, is TREC asked the broker straight out, you tell me the first time you were aware of this. So it goes back on you. It's not so much, they don't like the fact that somebody wouldn't abide by what the broker requires, nor what TREC requires the broker to follow. So again, it's going to come down really hard, but it's not going to happen anymore. It's just, it has caused a major issue on trying to get things reviewed and processed. Yes, Andrew?
What about current listings, Marilyn? Do we need to go back and get the CMA signed?
Personally, yes, since I gave you that form in 2011, that was the required form that I provided to you, it should have been in every listing, period. So you want to make sure that you have that. If it's in your file and you just didn't upload it, please upload it and we'll add it to the file.
How many of you probably need that anyway? Because if you got an overpriced listing that's been on the market for 6 months and you didn't provide a broker price opinion, aren't you doing a fiduciary level service to yourself and to the client by maybe addressing the issue why it hasn't sold? I think the right reason a lot of people don't want to do a broker price opinion is because it takes time and it also shows the client really the true picture, and you might not be real forthright by telling them, oh, let them, they want to get what they want to get. Who cares what the market value says? That's really not the fair way of doing it. That's a realtor code of ethics violation for taking a listing knowing that it's not going to sell anyway.
Yes.
Where's the form?
It's uploaded in the risk management documents. Where is the form? You'll find it in the Market Center intranet under risk management documents. Yes.
Email a CMA to the clients and have documentation.
She said if I email the CMA to a client, yes, you can upload that link, you can upload that email into your file, and that's fine. That'll be acknowledgement.
But ask for a confirmation so that there's an email back showing that they actually received it.
There you go.
Sometimes
That's critical.
things disappear.
You'll hear all about that when the panel convenes. Okay, so again, effective June 1st, you're going to get a status back, and it'll say, attention agent, archive blank documents and resubmit. So that's your cue that you've put maybe the listing in there 6 times, that you put in the lead-based paint pamphlet, which I do not need to have. The title commitment, I don't need that. You need it in your loop, but it's archived so only you would have access to it when you needed it. But not for me to look at it and review and make sure that we have everything that's necessary for you to get approval.
Oh, she loves it. Friday nights, that's what she does all night with her and her husband. They look at your contracts. Lead-based paint addendums.
Yes. The other thing is today, the panel's going to address, just as Steve said, about you getting a response when you send something. We're going to talk a lot about that. Pay attention to that. That's all a part of file documentation. We don't require that you upload your file documents. Some of the brokers do in this town. I know, because I do compliance for them, and they require, before it is approved, that agent has to upload every email, every communication they ever had with that client. We don't do that here. Yes?
All right, I'm fairly new. I've only been an agent for 3 months, and with all the documents I've been sending you, I'm trying to do dot loop. I'm trying to do my due diligence, if you will. So one of the contracts where I have, or one of my listing loops where I have the lead-based paint and all these other documents. So what you're saying is, if it's there, do you want me to archive those that are already signed?
No, I did
Or
not. I said blanks. In other words, what you'll do is sometimes you create documents or you'll bring them into the loop and nobody's signature's on it. It's not a fully executed document. In other words, the sellers haven't signed it and the agent hasn't signed it. I don't want those documents anymore. Okay? Unfortunately, some agents upload all extraneous documents and nobody's touched them or anything. And it doesn't make any sense. They're all blank. If they're not a fully executed form, I don't get it. That's from a contract side or a listing side. Okay, I don't want to see blanks anymore. The other thing I wanted to touch base with, and this is part of what Craig mentioned in his non-negotiables, is the advertising requirements. Trek is coming out hard and heavy. And why Trek is doing this is because other agents sometimes have a vendetta against you in their market area and they turn you in for a Trek violation of the advertising rules. We have probably 4 right now. We had one that is an attorney and a real estate agent, and he told me when he got that Trek complaint, he said, I don't know, this is not, I said, no. It's very clear, we told you in the addendum, this is a violation. He put such and such real estate company with his name, and Trek said, I have no idea who's involved with that company, okay? And he was cited. They do a citation program if the other broker doesn't have a vendetta against you. Otherwise, they will drag you through an ethics hearing and a complaint and a Trek complaint. And that's what we have right now going on. So sometimes it's anonymous. You are able to send an anonymous complaint. And when we challenged it and said that agent, we know by the barcode on their documentation who it was somebody who has a personal vendetta against the agent. So we challenged him, and Trek says, just because they're anonymous doesn't mean we're not going to get our attorney to come after you. And they will. They'll take over the lead, and Trek will come after you now, rather than the anonymous complaint. So there was a handout that was sent to you that was perfect, because Craig identified from the website, from your Craigslist, anytime you're going to advertise, exactly what you are required to by Trek. Kinsky Leffler has a wonderful article that we produced from the Texas Realtors Magazine for additional guidelines, but I don't know about you, but every time anybody reads that, they read something different. So what you'll see from Craig is a practical application of how to abide by the advertising rules and regulations for every kind of advertising that you're going to have. So make sure that you read that, and if you have any questions, you can give me a call. The other thing is on risk management issues. The one thing I want you to be aware of, when we had that issue where Steve Rogers helped us get out of jail and all these problems, the agent called me immediately. It was like a Friday night, it was something late. And that was the key to our success. When the agents provide notification right away to us, man, we can step in and we apply the practices that we have incorporated for best practices to assist with any of these issues that Craig has in place. And so what I'm telling you is the sooner you contact us, the better it is for all parties. And what's so important about this is that the other party was threatening the agent. So don't take threats lightly. I take them very seriously, so does Craig. Anybody who's threatening you or Keller Williams, we want to be aware of this because we want to make sure that we handle this properly from the very beginning. The biggest issue I have, when you read the independent contractor addendum, at the very bottom, we have an errors and omission professional liability policy. Paul's company has wonderful, provided us coverage on this, and so we have a policy that we have to abide by. There is no guarantee that any time you get sued, your claim will be accepted. There's not a guarantee. It's a rendition that's based on the carrier will look at it and they will evaluate, is this a covered claim? And if so, then they will let us know. We've had several agents who were not covered because once they failed to notify us immediately when there was an issue. And what happened is, we had just renewed. Then the agent says, oh, I knew about this several months ago, but here it is. They sent it now. And the carrier said, no, when you signed that application, you told us you did not know of any of these. So they totally disallowed the claim. So it was based on the agent's lack of notifying us is what caused them to not have coverage, not that the policy would not have covered them. So you see how important it is to get it to us immediately, because once we're aware of it, then we escalate and we provide notification based upon what we know. Half the time that I send notices, nothing happens because we handle it and take care of it. And all they have to do is close it because no longer a valid entry as far as a claim will have. But again, you must do that. Yes, Michael?
Can you give us examples of what you really need to hear about and what maybe sounds funny but you don't really need to hear about? So,
well, most of the time is the parties will threaten you. Well, why didn't you do this? If they think or have accused you of not having done your job, well, we need to know.
I would say if you feel something funny, tell Marilyn about it. Let her decide. You don't decide.
Yeah, this.
Yeah.
The policy has a very broad definition of what a claim is. The policy's definition of a claim is a demand for money or service, verbal or written, or something you believe to have a future for a demand for money or service, verbal or written. It is not just a lawsuit. So if you make a payment to repair something, replace something, and this is after close, then officially you have a claim if someone's made that demand on you. Now, 99% of the time, those issues don't escalate, but if the issue does escalate down the road, that's the worst case scenario. And my job as a risk manager is telling you the worst case scenarios, because if you take action on a claim and don't report it, and that issue escalates, you're not having coverage. And last year I had 3 claims with damages over $50,000 that were denied because the agent took action on the claim or took no action on the claim, didn't report it, we get served with a lawsuit, and you then now have no coverage. Guys, you pay to be a part of an organization. Let the people who run the organization make the decision on the reporting side. Don't take that upon yourself, because all you're doing is putting the firm and yourself in jeopardy.
Let's expand on that and take ego out of the picture, because I know that we paid on one person in this room who said, I'm not at fault. Clearly they were, and we told this person they were at fault, and we ended up having to pay their legal fees, and our deductible's $5,000, but every time we pay a claim, every time a claim is hit against our underwriter, Pearl, it hurts us. They make those risk assessments the next time we renew, and it impacts us in a very negative way. It's critical.
I'm going to add one element to that that's just as important. What it doesn't go against you is those environments where Marilyn was talking about, where you report the potential claim and we don't pay any money. That doesn't get held against you at underwriting. So there's no damage unless we pay money. You guys can do whatever you want.
It's like taking a Scantron test. Answer all the questions. Okay, you report it to us right away. Don't leave any blanks. Let us know when you've had something. Again, this person, in this room, great agent, top producer, but felt like, hey, it is not my fault. It was their fault, and we ended up having to pay on that. So it's critical that you let us know when something happens.
Even if it's not your fault, you don't have to, all you need to file a lawsuit is to go down and pay the filing fee, and not even that if you're indigent. So in our judicial process, the merit of the claim doesn't get screened normally until a lot of money has been spent and there's been a lot of pain and suffering on the part of all concerned. So even if you're sure that you're not at fault, and you may not be, if another party to the transaction or somebody else thinks you're at fault, if your antenna goes off, if you have some reason to think that there might be an issue, that there's some kind of trouble brewing, trust your instincts and go to Maryland and let the professionals make a judgment and help you decide what needs to be done. Marilyn and the lawyers and the leadership, they see patterns over and over again, and we're pretty good at spotting, distinguishing between serious trouble and something that can be resolved. But let me reinforce the fact that this is claims-made insurance. It's critical that you report any time the facts and circumstances suggest to you that there might be a claim asserted at some point. You must let Marilyn know so the insurance company can be put on notice.
And the big thing about that is when we do the renewals every year, we may switch carriers. And if we do switch carriers and you know about something and we don't tell the new carrier, big problems, big problems. So now you've been notified prior to us switching, and it was already known about, and now we're at this new carrier, like she was saying on the application, says, do you know of anything? No, we don't know of anything, but you guys did, you didn't tell her. That company can come back and say, hey, you knew about this, you didn't report it, we're not picking up that claim, you're going naked. That means Craig's pocket's gonna get dug into.
I'm just gonna add a couple more things too, and this is more on Stephen's side. Stephen's the attorney. I'm not an attorney. Stephen tells you the right and wrong, okay? I'm a salesperson by heart, okay? Grew up a salesperson, and it's just in my nature. I'm about mitigation. I'm about your time. When you talk about right or wrong, it sometimes just doesn't matter. There are plenty of cases that I can point to that you're 100% right, and we've spent $125,000 defending you to say that you're right, and you've spent over 1,000 hours worrying about it. Lawsuits isn't about right and wrong when it comes to your production. This has to do with your aggravation, your time, your family, your other clients. This is more than just right and wrong. So that concept of I'm right, yeah, that's great, but what's it going to cost you to be right? Okay, I don't mean to scare you. Well, no, I do. Because just one claim can force you into retirement. Just one. Never once have I sat or read in a deposition, I'm sure Stephen's never heard of this, or Marilyn's never heard of, I knew this lawsuit was coming. It's always been something to the effects of, I've been in business for 20 years and I've never ever had this happen to me before. Well, guess what? You win. It can happen to you.
What are the averages as far as, if you look at the audience of agents, who are most likely the ones to be sued? Tell them that.
Oh, you're taking my good opening. Ray, I'll let you go into break. No, Ray, I'm gonna give him something funny to laugh at going into break. How about that?
Okay.
How many people have more than 7 years experience?
Raise your hand. Hi.
Nice and big.
Hi.
Be proud of it.
Hi.
Okay, you're my nightmare.
Yep. All right.
70% of all of our claims come from agents with more than 7 years experience.
Because I knew more than everyone else.
Yeah, you know a lot more than everybody else.
Okay, what we're going to do is we're going to take a 10-minute break. Be back at 20 till 11.